U.S. debt is illegal and foreign corporations claim to be government. Judge's letter to John Kerry and UN Secretary Ban Ki-moon. Judge Anna Reitzinger's letter to John Kerry and Ban Ki-moon, UN Secretary General, December 14, 2015. And I quote, December 14, 2015, John Kerry, U.S. Secretary of State, 2201 C Street, Northwest Washington, D.C. Ban Ki-moon, UN Secretary General, United Nations Secretariat, New York, New York. Dear Sirs, it's a matter of urgent importance. It concerns either mistaken identity or identity theft depending upon each man's estimate of the situation. Very briefly, at the end of the American Revolution War, two distinct groups of people lived in the former colonies as memorialized in the Treaty of Paris, memorialized in the Treaty of Paris, 1783, Article 3, the free, sovereign, and independent people of the United States and the inhabitants. The inhabitants were and are, from the perspective of the free, sovereign, and independent people, British loyalists and subjects of the Crown permitted to cohabit our land via Treaty of Peace. At the end of the American Civil War, President Andrew Johnson declared peace on the land via three separate proclamations establishing an undisputed Treaty of Peace and commercial contract obligation honoring the fact that the free, sovereign, and independent people of the United States were at peace, and we have remained so ever since. No such peace was ever declared for the inhabitants, and no peace treaty in their behalf was ever signed, with the result that they have been at constant war since 1860. Ever since that time, the free, sovereign, and independent people of the United States have been non-combatants and protected persons recognized and honored as such, successively by the Liber Code and most recently by the Geneva Convention Protocols of 1949. In 1868, the United States Congress, operating as the government of the District of Columbia, established its own constitution as an incorporated municipal government and established a new municipal citizenship for the subjects of the British Crown called the United States Citizenship. For its own purpose and its own administration only, the words state, and United States were formally redefined to mean District of Columbia Municipal Corporation, and the word person was redefined to mean corporation. None of this had anything to do with the free, sovereign, and independent people of the United States, but in order to keep it straight, people informally described the inhabitants subject to the British Crown as citizens of the federal United States as opposed to the continental United States. In order to make sure that people were not deprived of the correct political status, the Congress passed the Expatriation Act of July 1868, which guarantees the right of the living people to determine their political status, and which also underscores the government's lack of authority to determine this choice for us. By 1933, the Federal Government Services Corporation provided 19 essential governmental services to the American states, was bankrupted by foreign creditors. Franklin Delano Roosevelt and the then governors operated federal state-of-state franchises of this municipal corporation, acted without delegated authority to create millions of foreign citrus trusts named after all living Americans, both the British subjects and the free sovereigns and independent people of the United States, and via false claims that they represented us in this matter, changed the political status of the free, sovereign, and independent people of the United States to that of, quote, inhabitants, end quote, so as to expedite commercial claims against their labor and property assets benefiting the privately owned and operated bankrupt government services corporations. The people were never informed. No disclosure was made. It was all presumed upon us by politicians acting without delegated authority. The free, sovereign, and independent people in our states were not even afforded the opportunity to exercise the protection of the Expatriation Acts because they were not informed of Roosevelt's action to arbitrarily change their political status to that of, quote, inhabitants, end quote, and were equally not informed of the federal corporation's claim that they were voluntarily standing as sureties for its debt. Everyone on earth will agree that it is impossible to object to a contract if you don't know the contract exists. And that is essentially the position that the foreign, sovereign, and independent people of the United States have been in as a result of criminal conspiracy on the part of our employees. As of 1998, we objected to these processes and claims, including any claim altering our birthright political status. The Internal Revenue Service and many other agencies were given notice at this time and in years thereafter. As of 2011, the United States Inc., Incorporated, that is, and its state-of-state franchises were shown to be in administrative and commercial default. As of 2015, the free, sovereign, and independent people of the United States have been forced to issue a new declaration of joint sovereignty and new sovereign letters patent in behalf of the free, sovereign, and independent people of the United States. Their states, defined by geographic boundaries, their living citizens, and their assets, and have joined with the Native American nations to assert their claims to the land jurisdiction of the United States owed to us free and clear. Any presumption the United States and its people just, quote, disappeared, end quote, because of criminal legal chicanery practiced against us by identity thieves and credit card snatchers wearing nice suits would be an inexcusable breach of trust, an act of gross criminal malfeasance. Which brings us to the current issues. Absent performance of the duty required by the United States to Statute at Large 153, there can be no actual change of one of the people's birthright status by any private contract or commercial obligation. By maxim of law, the creation of, quote, corporate personas, end quote, via the abuse of purloined copyrights of our given names is entirely the responsibility of those who created and named foreign citrus trusts and constructive estate trusts and now public transmitting utilities after us without our knowledge. The free, sovereign, and independent people of the United States are in fact the priority creditors of the so-called national debt and the employers and benefactors of those who have promulgated this criminal abuse of our trust. Our states of America are now and have always been separate from and foreign with respect to the federal United States, such that this becomes a matter of international law, diplomacy, and treaty. As the heirs of the American Republic, we are owed the Constitution for the United States of America and all due respect as living people, all interest as priority creditors of the various banks and governmental service corporations, and the return of our property, assets, material interests free and clear from titles and liens held under color of law by merely presumed secondary beneficiaries. We are also entitled to be set free from any and all presumptions of obligations for the debts of the federal United States, any obligations of federal U.S. citizenship, and any duty to perform under private statutory law. We are owed the return of the copyright to our given names and all assets that are naturally ours. As a result of the criminal fraud, breach of trust, malfeasance, and personage practiced against us by our predecessors in office, we have been press-ganged into the international jurisdiction of the sea, suffered inland piracy and unlawful conversion, identity theft, copyright infringement, and credit fraud. Many Americans have suffered false arrest, armed extortion, racketeering, and eviction under the false presumptions and mischaracterizations created by this systemic fraud. It is past time for these outrages to end. Mr. Carey, you are responsible for the affairs of state for the organizations you represent. Our nation is foreign with respect to the federal United States. This is therefore a matter of international diplomacy and failure to recognize international obligations of long standing. As acting U.S. Secretary of State, we presume it is your responsibility to create and define the administrative protocol, forms, and instructions that will allow all federal employees and agencies to differentiate between inhabitants and the foreign, sovereign, independent people of the United States. There should be no doubt in your mind, nor in theirs, what it means when we draw the line and identify ourselves as one of the free, sovereign, independent people of the United States. There must be a straightforward and official means to explicitly declare our political status and to correct the civil records maintained by the probate courts, and there must be an end to the false presumptions and hostilities being offered against us by federal employees, agents, subcontractors, and secondary creditors, including their bill collectors, the American Bar Association, the Internal Revenue Service. We are your priority creditors and not the banks, which are using the various governmental service corporations as fronts to veil their self-interests in these manners. Mr. United Nations Secretary General, the United States of America, the States of America are not members of the United Nations organizations. However, we have filed claim against your members and against your organization for the return of our property from the trustees in receipt of our copyrights to our given names and titles to our assets held under color of law by secondary beneficiaries. If you do not wish to be identified as a collaborator in crime, you must assist in healing the breach of trust and returning the assets to the rightful heirs and beneficiaries. Steve Curry and his wife Sandra Taylor are representing millions of Americans who are being held under false arrest, under false presumptions of political status, and under non-existent jurisdiction by private courts, being allowed to function in our land in violation of both their corporate charters and the treaties allowing the offending corporations to be present in our land. These living people, who are each one of the free, sovereign, independent people of the United States, are being held as political prisoners by corporations that have no right to exist. Corporations are acting as self-interested crime syndicate extorting labor and their assets from their priority creditors under conditions of false presumption and duress. Steve Curry and Sandra Taylor made it perfectly clear in the, quote, Montrose County Court, end quote, an incorporated franchise owned and operated by the District of Columbia Municipal Corporation District Court, U.S. District Court, that they are of age, competent, and have 4 years claimed their birthright status as one of their free, sovereign, and independent people in the United States. They also made it clear that no mortgage established against their private property can be exercised by secondary creditors, as no loan was received by them, and the sum total of the alleged transaction merely resulted in the perpetrators obtaining an unregistered security under conditions of non-disclosure and semantic deceit, benefiting secondary creditors, fraud in other words, which was expedited by employees of the federal United States. These very same employees owe Steve Curry and Sandra Taylor full protection on the high seas and navigable inland waters, meaning all venues of international jurisdiction, as well as full faith and credit. Nonetheless, and despite both national and international law supporting the Currys' political status and their right to claim it, despite their nature and position as priority creditors of the federal United States doing business as the United States of America minor, Steve and Sandra were attacked and assaulted under false presumption by members of the American Bar Association acting as privateers, secretively owned and operated in concert with the Internal Revenue Services by Northern Trust, Inc. Their private property was trespassed upon by armed commercial mercenaries pretending to be public deputies. They were detained under condition of false arrest tried in a private corporate administrative tribunal without jurisdiction and presumed to be subject to foreign statutory law. They are now being held and abused as political prisoners and subjected to false arrest and arrest seizure by their own employees who are being misdirected by the Obama administration to continue this predation against the free, sovereign, and independent people of the United States to whom they are indebted. The Curry family, like the Bundy family, made their political status crystal clear a long time ago, and the courts have no right to question their choice. The courts indeed owe them a discriminating inquiry into their political status per Baker versus Carr, 369 U.S. 186, 1962 case. Once the question of political status has been raised, which it was and is being raised repeatedly in this and every other case wherein statutory law has been misapplied and jurisdiction has been falsely assumed. Steve and Sandra, like millions of others, are civilian non-combatants and protected persons who have been arbitrarily and self-interestedly presumed upon by members of the American Bar Association who are operating private foreign corporate administrative tribunals under false pretenses and routinely ignored the political status of the people they are addressing, the jurisdictional barriers they are violating, and the criminal and repugnant claims they are making upon their priority creditors and benefactors. The American Bar Association and the Internal Revenue Service are both owned and operated by Northern Trust, Inc., a private for-profit foreign debt collection agencies. They are not units of government, not professional associations, not even non-profit organizations. They are criminal syndicates operating under color of law and semantic deceit in violation of their corporate charters and the Bar Association Treaty, allowing them to be here. Whereupon we have established a formal commercial obligation lien against the American Bar Association and the International Bar Association and the Department of Justice, which again, as it turns out, is nothing but a private corporation and subcontractor having no public function or office or delegated authority whatsoever. These are the facts, gentlemen, and we are the people, the free, sovereign, and independent people of the United States who severed all obligations to the British Crown more than 2 centuries ago, who are the priority creditors of these criminals, who are the lawful entitlement holders of all actual property in the continental United States, who are the beneficiaries of the National Trust, not the beneficiaries of the public charitable trust. We are the people to whom John Kerry owes essential governmental services under Article 4, Section 3, Clause 2 of the original equity contract governing our relations with federal United States, and who are fed up with the gills with the misadministration, malfeasance, incompetence, and reckless dishonesty of the banks, their governmental service corporations, and the private corporations, corporate officers who have been impersonating public officials in demonstrable bad faith. We, the free, sovereign, independent people of the United States, are demanding the immediate publication of a competent and mutually acceptable administrative process to be used to correct the political status and civil records of our peers who have been mischaracterized as U.S. citizens and coerced under condition of semantic deceit and non-disclosure to accept this foreign and prejudicial political status. We note that this administrative action is required by both national and international law. We also demand the release of Steve Curry and his wife from the custody of Montrose County Court and the correction and censure of the U.S. District Court, which has failed to properly operate and instruct its corporate franchise doing business as the Montrose County Court, a failure that has resulted in assault, trespass, duress, false arrest, endangerment, and harm to the free, sovereign, and independent people of the United States who are uniformly owed due diligence and performance of essential governmental duties, including protection against international crime, false claims made by undeclared foreign agents, misrepresentation, unlawful conversion, personage betray, constructive fraud, false presumption of political status, falsification of public records, false arrest by foreign commercial mercenaries, trespass upon private property by same undeclared foreign commercial mercenaries, assault against peaceful non-combatants who are protected persons under international law, infringement of copyrighted names, false claims of indebtedness and status as sureties for commercial debts, imposition of bogus maritime salvage liens, and occupation of vacant public offices by private commercial interests acting without delegated authority or jurisdiction while seeking to gain private advantage from public resources. All federal United States personnel and agencies must be similarly informed and instructed to prevent their misdirection and the misadministration of their duties. Specifically, all federal United States personnel and agencies under contract and owing the federal sovereign independent people of the United States protection in all international jurisdictions and also full faith and credit as their priority creditors are required to immediately cease and desist all those repugnant and criminal presumptions resulting from FDR's fraud as fully described in our published affidavit. You know something is wrong when an American affidavit of probable cause. The United Nations Secretary General is responsible for the enforcement of the pledge of the federal United States to uphold the principles of international law and the published agreements and guarantees represented by the Universal Declaration of Human Rights and specifically the right of self-declaration of political status. The federal United States Secretary of State John Forbes Kerry is responsible for recognizing and honoring the free, sovereign, and independent people of the continental United States and for the proper functioning of all inhabitants and agencies under their contract to serve them. He is also responsible for the enforcement of the Bar Association Treaty and the lawful functioning of all foreign agents inhabiting the land jurisdiction of the United States. These corporations, Northern Trust Internal Revenue Service, American Bar Association, Department of Justice, District of Columbia Municipal Corporation, United States Corporations Company, Fidelity Investments, District of Columbia Municipal Corporation, DBA, U.S. District Court, and its franchises doing business as state of courts and county courts, among other legal fiction entities operating in the international jurisdiction of the sea, have been allowed to trespass upon the land jurisdiction owed to the free, sovereign, and independent people of the United States, and to engage in predatory activities against these innocent and non-combatants, including press ganging, inland piracy, securities fraud, copyright infringement, and kidnapping. You have both now been fully informed and enjoined from making any other presumptions of fact related to us or any other of the free, sovereign, and independent people of the United States. You have been also given notice of serious violations of commercial contract and treaty, and also international violations of human rights being practiced against Americans by foreign corporations, which are violating their corporate charter and the treaties allowing their presence on our land. We are calling for the immediate liquidation of all federal corporations found to be operating as criminal syndicates, the arrest of all federal officials who fail to honor their obligations to the United States of America and people living within their boundaries, and the immediate correction of political status owed to all Americans, including Steve Curry and Sandra Taylor, who are being held under false arrest and false presumptions to foreign political status. By occupying the office of the United States Secretary of State, John Forbes Kerry has taken on the duties of that office and is obliged to perform according to treaty and commercial contract owed to the free, sovereign, and independent people of the United States and their geographically defined states and their states of America organized as incorporated trading companies. Failure to do so and to provide remedy for these current outrages will be proof of purposeful criminality, malfeasance, and criminal intent on the part of Mr. Kerry and the federal United States, whether by act or omission. Similarly, the federal United States has signed the Universal Declaration of Human Rights and the rights of self-declaration and has no basis for objecting to the similar natural and unalienable rights of other creditors who object to fraudulent misrepresentation and wish to obtain correction of a merely presumed political status that is being foisted off on them against their stated and long-established will. American state citizens must be recognized and accorded the political status, set free, released free and clear of any presumption of unnatural or adopted political status not in compliance with the public law, free of obligation related to liens or debts established by any presumed secondary beneficiaries, freely supported in the possession and use of their lawful currency and private and public property interests, including control of the copyright of their names, their estates, and their material assets. The federal United States and any other foreign interests which have infringed upon our natural copyrights and abused our given names in commerce are 100% and uniquely responsible for all debts and administration of these legal fiction persons by maxim of law, and may not be allowed to continue making and enforcing any false presumptions of obligations, duty, or responsibility with regard to these entities which have been created without the knowing consent of and full disclosure to the free, sovereign, and independent people of the United States. We are owed the national debt of the federal United States as a priority creditors, therefore, thereof, and may not be mischaracterized as debtors of any kind. We have the only lawful standing with regard to continental United States on the land and are not being represented by any corporated entity with regard to our land assets. And that includes any presumption by the federal United States and the District of Columbia Municipal Corporation, the American Bar Association, or any other foreign corporation. Our states are geographically defined, and our states of America are unincorporated public body politics competent to convene a continental congress and to direct all affairs of state related to us and our holdings. The fact that we have not taken action in recent memory in no way forestalls or preludes our right and ability to do so. We are not subject to any presumption of political extinguishment, nor incompetence to trade or any enmity towards any nation or people. We have maintained the peace for 150 years. Our silver dollar and other forms of our lawful national currency are still in service and widely used in trade throughout the world, serving as one of the few rational standards of values in existence. We have never authorized the federal United States nor the District of Columbia Municipal Corporation to misrepresent us, change our political status, copyright our name, and abuse them, indebt us for their own debts as presumed sureties, or take other actions not specifically stipulated in the original equity contract known as the Constitution for the United States of America. And in fact, we have remained unaware of all these nefarious activities being carried out in our names until the present times, when we have given full notice of our claims and intent. Any New Deal proposed by Franklin Delano Roosevelt was not properly nor fully disclosed, not lawfully implemented, and not accepted by the free, sovereign, and independent people of the United States. No valid signature can be presumed to exist under duress and semantic deceit, and no acceptance of a fiat monetary system imposed for the convenience of needs of the foreign government may be deemed to affect us, our political standing, our jurisdiction, or our material assets. Those corporations responsible for the deplorable criminality exposed by the public records and detailed by the claims and testimonies of living witnesses to their crimes, must be liquidated and their assets delivered to their actual creditors. The recent misappropriation of our assets again by the so-called county executives, who are now in receipt of our gold originally purloined by the World Bank and IBRD, acting as secondary creditors in the 1933-34 bankruptcy of the United States of America, Inc. As a case in point, these counties are franchises of foreign corporations that have no lawful relationship or public office related to us, so that the World Bank and IBRD have merely succeeded in handing off gold they have stolen from us under false pretenses to more collaborating international criminals who are also, at best, secondary and merely presumed beneficiaries pretending an interest in our estates. This and other forms of international crime and collusion must be brought to a halt immediately. The World Bank and IBRD must be sued in behalf of the actual priority creditors, heirs, and entitlement holders, a duty that falls upon Mr. Kerry, Mr. Liu, and President Obama, all of who have occupied vacated public offices as employees of private corporate enterprises, and must either perform the duties of the public office and protect the interests of the free, sovereign, and independent people of the United States, or admit that they have been impostors and criminals bent upon abuse of the public trust for private gain. These are all matters of criminal and international law which have been grossly misadministered by private corporate officers pretending to hold elected public offices, and by international banks operating governmental service corporations pretending to be actual governments, and all of which must be properly and unequivocally corrected in favor of the actual priority creditors of those same banks, the living, free, sovereign, and independent people of the United States. Sincerely, Judge Anna Maria Reitzinger, C.O. Box 520994, Big Lake, Alaska, RFD 99652. So that's the end of it. Obviously, she's calling for cancellation of the debt, which is placed on the shoulders of all American people. And they are the owners of the United States and the United States currency and their own assets, and they are not in debt to anybody. So I'll leave a link below for you for this.